solved because of our overall decision. This means that we are able to change conception of language. That's Sheen Evans, the one I see, because we change the language of the law of the books that allows for the justification of the abortion restrictions based on the masculinity of man. I will explain why that is applicable on the Solvency debate now. Down to the conditionality argument. It's not only about what you do, it's about what you justify. The interpretation of conditionality is uniquely abused because they justify running condition. What they do is they run two alternative actor counterplans and this round functionally because they are not because they are running a Congress counterplan and one is having the Supreme Court, which means that there is a uniquely abusive argument in this context. They will say that their counterinterpretation solves back all of our offense, but they can see that their counterinterpretation is not being met because it's not a critique alternative. It's two different policy level alternatives for the way in which to compete. Additionally, this is the type of arguments that justify any type of conditionality, which is bad interpretation because can justify running 9 counterplans. The affirmative never be able to win because they can never permute or have any type of weighting on our offense against the counterplans. When the competitive equity outweighs any risk of their offense, especially one in which affirmative teams can never win. Everybody goes for and puts the activity, or we are not able to have any type of advancement or educational activity. Additionally, all their offense is solved back by our interpretation that you have to have dispositionality. Dispositionality means that you can run multiple arguments, but you have to allow the affirmative strategic options in order to have any type of check or fairness in debate because you are not, because you don't do this, you preclude any type of offense in a world where we don't make the permutations or the arguments. You cannot be stuck with the counterplane, which means that this is horrible for any type of affirmative interpretation or policy option. In the real world, additionally, they can see that permutations cannot check any risk of abuse because even if we straight turn the argument, there's only one in which the permutation could never check the abuse because they could just take the argument and then of our offense gets going to go in and they can go for the other type of counterplane, or they could use our counterplaners against each other because this is the Supreme Court versus the Congress in the system debate round. Additionally, all the reasons why straight turners don't check our offense with their interpretation because the too easy decision making is well compatible with life advantages there are even improves the reciprocity of our argument. If permutations check into any type of dispositionality, please only be able to make the types of permutations plus their interpretation is de facto. It's this types of conditionality. If we want that these are strategically advantageous to the negative and allows for no affirmative win, this means you should for our interpretation. They say they solve for our offense with the counter interpretation. This is all answered above how you're never going to be. We can never check this because it's two counterplanes. It's not a counterplane and a criticism. They're never coming to terms with this. They say we solve the infinite regression. They've conceded that they allow for 5 different counterplanes. You could do the state courts counterplanes, the Supreme Court, and the Congress, and then have the president too. There's no way that firms will be able to check back any type of offense. They say this is the key to the topic, but they have no argument as to why this is necessary for them to generate any type of fair offense, especially in a world in which disposition and checks back all that. Additionally, they concede that this type of argument is completely relevant in a world in which they got to prep for entire last night against our two affirmatives, both of which are based on the Casey decision. There's no reason why this is key to strategic discussions or any type of possibility. They say this is key to counterplanes and negative flexibility, but you don't have to have alternative actors doing it in order to win other types of debate rounds, especially in a world in which we are not able to answer all the net benefits. They say disposition is arbitrary, but this is brand new. Additionally, the conditionality is uniquely worse, plus that they don't have any reason why our unique interpretation of dispositionality is bad. Firms should get to stick you with some option of the counterplanes is the only way to solve for our flexibility. They say our flexibility, but they are checked by the entire being of the entire night. They say it's uniquely worse, but they have no offense to why this is not uniquely abusive in the context of this debate. And now to the Solvency debate, looking straight across the argument about the Whitford, two pieces of Whitford evidence as well as the Irrigari evidence. They concede that we do not essentialize and we create a new point of exposing the exploitation of women and the way in which people relate to each other, where they can each create their own struggles and strategies for situations. This is impacted by the Irrigari evidence that indicates that this type of suppression of sexual difference is what guarantees the extinction of genocide, which is worse than what has occurred. We are able to solve for the reasons why people commit violence against each other. We solve the internal links to their impact. They have no offense, which is why this is not beneficial. Now to the criticism. They may counterplan out of the word in, but it does not solve our affirmative. We cannot use any risk calculus on the page, and they can pass to prove why they solve the impact, especially in the context of the affirmative world. And based on the Solvency debate, their impact evidence is the reason that leads to domination and exploitation is the relation regards the other as a means to ends. The two-hander does not answer the argument of the counterplan about how it objectifies the Supreme Court and Congress for political gains because they assume that there is a Congress or a Supreme Court. This negates that there are members of the Congress and members of the Supreme Court. And they are going for a linguistic criticism, make them defend the language that they are doing on the types of both of the counterplanes in the round. Additionally, they may change language and plan in the counterplane, but they don't meet the threshold for their impact arguments. Why is there any risk about it? For why it leads to these types of impacts? This is a bad standard for evaluating their impacts. Also, the terminal impacts too. Their argument is exploitation to, and our speech for our interpretation about how we can solve for sexual difference and change the institution. They say the counterplay doesn't do that, but they have no evidence on this. We've also explained this above. They say they don't justify metaphysical bias, but the fact that there is no unique risk that the affirmative would lead to this any more than the status quo, or that we wouldn't be able to solve for this with the permutation means that there is no evidence to this. They say the impact is based off of the but they have no evidence. Their evidence is contextualized in the oppression of the other because repression of sexual difference, which we do not do. They conceded this would be solved by the Sheehan evidence as well as the evidence that we read on case in the Zurich evidence. Additionally, they say we view people as metaphysically, which is useless, but I have already answered this above about the bureaucracy and things like that. Additionally, they say that they have no answer to the permutation in the 2 and R's to why the symbolic change is necessary in the world of the that which means you should prefer Sheehan evidence and the Zurich evidence, which is above. They say short circuits our ability to solve, but they have no argument as to why it's specific enough to the affirmative and why our interpretation is necessarily bad because we allow for a recognition of difference and say that there is a multiplicity of institution, which means you should err out.
Okay.
The alternative text.
You want the M?
Oh, there's a mark in one of those cards, but
This one?
I stopped at this mark, but then there's a third card and I didn't.
It's right here. It's right here.
Okay.
You talking about this one?
Yeah. This one, I didn't stop at the one.
Okay.